Hello everyone, I am Advocate Akhil Solanki, Associate at LEXIS and Company. So today we're going to discuss a view of Meghalaya High Court in which the court alleged victims' sole testimony found reliable can be used to decide whether case for conviction made out or not. Therefore, the Meghalaya High Court on Tuesday observed that the statement of an alleged victim girl in POCSO case has telling effect with regard to the fate of the criminal case, as the sole testimony of reliable witness, more so when alleged victim of sexual assault, will pursue and convince the court as to whether a case has been made out or not as far as conviction is concerned. The observations were made by the court while hearing an application under Section 482 CRPC seeking quashing of criminal proceedings in special POCSO case under Section 376 IPC, read with Section 3A and 4 of the POCSO Act. The counsel for the petitioner submitted that a complaint came to made by the chairperson Child Welfare Committee alleging that a marriage had taken place involving the petitioner, herein the alleged victim minor girl being below 18 years of the age, which culminated into an FIR. Therefore, in order to substantiate the argument, the counsel also invited the attention of the court toward the statement of the alleged victim under Section 164 CRPC, wherein it had been clearly said that though she went to the house of the petitioner on the said date, there was not physical sexual contact on that day night, as she stayed with her mother-in-law and returned home the next day. This statement was also reiterated in her deposition before the court as PW1. Contesting the plea, the respondent argued that the medical report submitted by the doctor, who has examined the victim girl soon after the FIR was lodged, shows that hymen of the said victim girl was not torn at 7 o'clock position, which in turn imply that there exists a strong prima facie case against the accused petitioner and under Section 376 IPC read with Section 3A4 of the POCSO Act, and hence the petition should be dismissed. After hearing the opposition contentions on plea, the court observed that the clinching factor of this case is the statement of the alleged victim girl herself, when she clearly stated in a statement under Section 164 CRPC and also while disposing in court as PW1 that there was no sexual intercourse with the accused petitioner on the alleged date of occurrence and that the marriage will take place only when she has attained the age of majority. This statement of the alleged victim girl will have a telling effect as regard the fate of the said criminal case, as the sole testimony of the reliable witness, more so an alleged victim of sexual assault, will persuade and convince the court as to whether a case has been made out or not. As far as conviction is concerned, the bench underscored that declining to accept the contention of the government advocate who had drawn support from the medical report, which had indicated that the hymen was torn at 7 o'clock position, the court said that there was no evidence of violence used or any kind of injury on the body of the alleged victim girl. There is also no clear finding as to whether the torn hymen was an old tear or a recent one, the court pointed. Finding a fit case for interference, the court allowed the petition and the proceedings in said special POCSO were accordingly set aside and quashed. That's all for today, guys. Thank you.